What's interesting too, though, is often that is articulated in the governing documents themselves.
Yeah.
The governing documents will actually say that these have to be applied equally amongst the homeowners.
Yeah.
So when there's a violation, not only do you get a violation of Davis-Stirling, but it's also in violation of the governing document. So it becomes two causes of action.
Oh, interesting. Yeah. Okay. Before we jump into the next one, I want to roll back just one quick second. Can we define the word variance for those that have never heard it before in this context?
I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hello and welcome back to another episode of Bad HOA. I have Marty today.
Hello there. Good afternoon.
Good afternoon. Welcome back.
Thank you.
Very fun, exciting episode. And should we just jump in with the elephant in the room?
Yeah.
Start with your sweater.
Thank you.
Beautiful.
Empowered homeowner.
That you are, Marty.
Before we get started, I just hold on. This is annoying, but I'm kind of thirsty. Hold on.
Okay. Empowered homeowner mug?
Oh my goodness.
Well, that's interesting.
Wow.
What a coincidence.
But I'm gonna need something to carry all this stuff home.
You got
all
a lot
this
to
fresh
carry.
stuff. Yes, I do.
Well, how are you going to get home?
I guess I'll have to use my tote bag, my empowered homeowner tote bag. Yeah. But it is hot outside.
It is very hot outside.
So I know the sweatshirts doesn't make sense, but to guard from.
You know what? Need sun. I hear you. I got you covered. This is turning into a QVC episode.
Oh yeah. The stitching is phenomenal on this.
So empowered homeowner merch.
Yes, it's here.
Let's talk about it.
Yeah.
So, you and I have been talking about just empowered homeowner, sort of the empowerment ecosystem we created.
Yeah.
And, one of the things that I think really can send a strong message, when you have a homeowner, when you're going to a board meeting, I mean, it's subtle, but it's not so subtle.
Yeah.
And you think of it, everything to us is strategy, tactical. And I will say, if you showed up to an IDR meeting or a board meeting and you had an empowered homeowner hat on, I mean, it sends a message.
It does. It really it's funny at the same time. But imagine walking in with that.
Oh, 100%. And so what we try to do, it's fun. It's, sort of, I think it's sort of a fresh take on what we do.
Yeah.
But at the same time, optically, it does say something.
Yeah.
It's sending a message. And in these meetings, I mean, that is the message you want to send.
I think at the end of the day, we've always said that the message is, don't mess with me. Right? I think there's no more subtle way of doing that. Not so subtle way of doing that than showing up in this beautiful sweatshirt.
Well, if you look at the jungle, right? Certain frogs, certain spiders, they have colorful indications that they're venomous.
Yeah.
Yeah, we're not saying we're not going that far. But the point is, this might be a very nice way, or as we see it, it's a very strategic way.
Yeah.
To say, listen, I'm empowered, I understand my rights, and I'm showing up prepared.
Yeah. And everyone, we did go through this homeowner empowerment kit last time. And we just bound it and put a nice way of you like a workbook basically that you can work in. So these are great. This is great. So we have all sorts of fun stuff coming soon.
It is all coming soon, but because we have this first drop that shipped to our office, we have a special offer.
Yeah, we're gonna give the stuff, our first shipment away,
all for free.
All for free.
Again, this is empowerment. We're not trying to monetize on this.
No. This is
we
purely,
just want this out in the market. Yeah. We want homeowners to have it. And, for the first drop, if you're interested, if you'd like the free merch, what do they have to do?
It's easy. You look at the merch and it says Bad HOA subreddit right here.
Go to our subreddit.
Go to our subreddit. We will have a link to the episode as well, and we will put it there. A link in the episode for this particular. We'll put a link right there in the description there. For the episode.
First come, first serve. It's limited. We don't have endless supplies, but if you get there, if you're one of the first in line, we'll ship it for free. We'll send it your way, and we're just thrilled. We're excited.
Yeah.
So
on that note, let's get into the episode.
Hard transition. Okay.
Yep.
Back to business. QVC is over.
Unfortunately.
All right. So
we'll put this so it's not so distracting to the people behind it.
Yeah, maybe we can.
Clean up there you go. There you go. So you saw it reveal. It's like Steve Jobs pulling out the iPhone, like at the stage. And I'm like, oh, do you have? I happen to have it right here.
All right. So this is a revisit. We are revisiting this episode or this topic, I should say.
Yeah.
And what's the topic?
Selective enforcement. We covered this. We've been doing this podcast for. We're nearly 50 episodes in. Over the course of a couple of years now. And obviously it's been tremendously rewarding. And this is one that comes up frequently. I felt like we needed to revisit that because there's so much content that we've put in since then to kind of put together a framework and structure and like scaffolding so that homeowners can get some sort of a framework to fight their HOA without an attorney.
Well, it's also the tools.
Yeah, it's exactly my point.
It's been an evolution. The show's been an evolution. How we approach the space has been an evolution. Obviously, it was always about education and empowerment, but also very tactical tools that homeowners can use when dealing with very specific dispute types.
Yes.
And selective enforcement, as a lawyer, we see it all the time.
Yeah.
So many of our, potential clients that come in, or clients that retain, they're dealing with selective enforcement. Yeah. Because it's rampant in California and Florida. So today we're going to sort of revisit the topic, sort of go over what it is, how to address it. But I'll let you take the lead over, Marty.
Perfect. Let's get into it. Selective enforcement comes in two flavors, right? The first one is targeting, right? So we'll get to the second flavor after we define the first. So legally, this happens when a board enforces a rule against one specific individual or group while ignoring others who are doing the exact same thing.
Yeah, and this is one where often if you look under the hood, you got a bad board member. Yeah, you have a tyrant, you have a meddler, you have someone with some sort of malice. Yeah, and often it's the board president and they target the neighbor, or they target someone that historically they had a falling out with. Yeah. And so how it comes up is, it could be a variety of ways, but one is fines. You, the homeowner, are getting fines for something that everyone else is doing, but you're the only person getting the fine. Yeah. Targeting, right? Yep. Or you want a specific paint color, or you want to install a feature on your home. Everyone else has it, but the Architectural Control Committee keeps denying your application, even though everyone else has it. So that's a really good example, or those are good examples of how selective enforcement materializes.
Yeah, so that can be in the form of like a vendetta, like someone has that against you, or president doesn't want to see solar on your roof because it
impacts the president.
Impacts yeah, exactly. Right. Let's give a couple examples here, actually. Okay. Political signs. And the board forces you to take down your political flag. Meanwhile, neighbors flying flags for the other side are ignored.
Yeah, they don't like your politics.
Yeah. And that comes up. We've seen this happen quite a bit. That's actually quite a lightning rod.
It is, and then it runs into First Amendment, freedom of speech, and it becomes sort of this constitutional issue. But yeah, you often see these board members, they have a political agenda or affiliation, and they're trying to shut down everyone else. Yeah. Well, selective enforcement, right?
Yeah. The ignored rule. Kind of stumbled that one, right? You're cited for hanging planters on your awning. The HOA has ignored the rule for 10 plus years, and half the community has the same planter.
Yeah, that's sort of going back to the original concept where for some reason you're being targeted and everyone else is given a free pass. Yeah. And again, it could be you individually, it could be a group of you. Yeah. Maybe you have a group of friends and the board president or the board, they just don't like you. And all of a sudden, your group is getting fined. Yeah. That's selective enforcement.
Yep. Third example would be the paint color. You paint your house an unapproved color and get fined immediately. A neighbor has the exact same color for years with zero consequences.
Well, again, at the end of the day, you're looking at equal application.
Yes.
How is the board treating everybody? And it can't be arbitrary, can't be capricious, and yet the board is acting in that way.
Yeah.
And so somehow you have a target on your forehead.
Yeah.
That's a problem. That's a huge problem in California.
Yeah.
For the board.
Yeah. All right, let's go to the flip side of that, right? So there's the other flavor, right? The other side of the coin, it occurs when favored homeowners receive special exceptions that are not applied uniformly to the community. So the exact opposite of that. So the board member gets special treatment or their friend.
Yeah, so that's the preferential treatment side of the coin.
Yeah.
So if you think about it, if you're getting targeted and everyone else is getting a free pass, that free pass group, that's a preferential treatment scenario.
Yeah.
And so it could be the board members, procuring preferential treatment or their buddy.
Yeah.
The board president knows for a fact that their buddy is in violation, but does nothing.
But ignores it, yeah.
But you, because they don't like you, you're getting targeted directly. So there's a preferential treatment arm to this that often happens. So when we talk about selective enforcement, it's not uncommon to look at the other side of that coin, which becomes a preferential treatment argument.
Yeah. Let's get some examples. And we just kind of outlined one. The board's buddy. You apply to build a gazebo and gets denied. The board president's best friend builds one without ever submitting an application.
Yeah, well, what's great too is when the board president submits and the board president gets the gazebo. I mean, that's blatant. Right?
Yeah, yeah.
But it happens all the time.
Yeah. Retroactive rubber stamping. A favored homeowner installs an unapproved front porch screen. Instead of issuing fines, the board grants a special variance. The board then updates the rules to ban screens for all future homeowners. Wow.
Yeah, again, it's often someone on the board who secures the variance, or it's their buddy, or there's an affiliation. Now, if you want to get into an interesting scenario, this is where you get, we talk about the different personality types.
Yes.
Quite a bit on the show. You have the tyrant, the meddler, the incompetent, or the fool, but you also have the self-dealer.
The self-dealer.
So, we've seen scenarios before where the board president is getting kickback from homeowners to procure a variance. Think of that. They're essentially taking a bribe or greasing the wheel.
Yeah. Yeah, it's absolutely unbelievable. And it feels like, this is in the guise of doing this for now a couple years, but why would you just not tell them yeah, right, and you're going to get removed ASAP for this bribery?
Right, but I guess human nature, they're in a position of power. And often, as we've seen it historically, the self-dealer gets in that position to monetize. And these opportunities come up. They see someone, it's Bill from down the street. They really want to get the gazebo in. They're willing to pay some extra dollars. They know that someone that they're talking to is on the board. They're willing to pay, a couple grand to get it through.
I guess it could be on the flip side of it if you think about it. It's board president says no, and what do you think about my friend Benjamin?
Right.
Maybe he and his couple buddies maybe have a different perspective.
And all of a sudden, the board president becomes the self-dealer. But again, that's preferential treatment.
Yes.
Although it's motivated here monetarily, sometimes it can be motivated through malice. Yeah. Sometimes it's motivated through just pure self-interest.
Yeah. All right. The 1 out of 11, 10 homeowners replace grass with desert landscaping, no enforcement. The 11th homeowner receives an aggressive violation notice.
The 1 out of 11, these scenarios are often very interesting when you start to look at the geography of the neighborhood. And what I mean by that is, everyone's getting a variance, or not a variance, but no enforcement.
Yeah.
But the home that's getting enforced is 2 doors down from someone on the board. Right? It somehow impacts someone on the board. And I've seen that time and time again, and it kind of makes sense.
Yeah.
Right? They're sort of, again, that's sort of a form of that self-dealing, preferential treatment. They're using their power because, way down the street or in other sides of the community doesn't really matter. Yeah. But it does when it's right next door or across the road.
Yeah, when you're looking at it.
Right.
Yeah. Excuse me. All right. Let's talk about, we're obviously in California. You're a California attorney. So let's just hit on a little bit about California, the Davis-Stirling Act, and how that impacts it. So the civil codes. There's no single law titled selective enforcement. However, the Davis-Stirling Act requires the, quote, uniform application of rules through multiple provisions. So we'll talk, there's a few key civil code sections I just want to hit on real quick. Civil Code 4350, the enforceability of operating rules. And then there's 2 bullets here, and then you can talk about it. The operating rules must be reasonable. The rules must be applied equitably.
Yeah, that's your safeguard, right? That is meant to sidestep this selective enforcement or this arbitrary and capricious approach to the application. What's interesting too, though, is often that is articulated in the governing documents themselves.
Yeah.
The governing documents will actually say that these have to be applied equally amongst the homeowners.
Yeah.
So when there's a violation, not only do you get a violation of Davis-Stirling, but it's also in violation of the governing documents. So it becomes 2 causes of action.
Oh, interesting. Yeah. Okay. Before we jump into the next one, I want to roll back just one quick second. Can we define the word variance for those that have never heard it before in this context?
Yeah. So a variance is something that is not authorized, not permitted because of maybe the CC&Rs, or there's something that says, no, you can't do this.
Okay.
But the association will come in and say, you know what, we're going to allow it for some reason.
Interesting.
So a good example would be, there's a reliance issue. Let's say the board comes out and authorizes a swimming pool or something that typically isn't authorized.
Okay.
The homeowner relies upon it, and because they get word from the board. And let's say it was confirmed and there's this real reliance issue from the board where the homeowner truly believes they can do something.
Okay.
Sure enough, it actually was in violation of the CC&Rs. In that scenario, some sort of resolution might actually be a variance.
Oh, interesting.
So it's something that you shouldn't be doing that you did, and there's reasons or there's a basis to authorize it notwithstanding.
Would an example of that being that the board or like the Architectural Control Committee approved something, you went through the construction of it, it's now pretty substantial, and then it turns out they made a mistake?
Well, that was my point. Yeah.
Okay. Okay.
Yeah.
I just wanted to reframe that a bit.
I guess that was a good way of doing it. And so, if you look at it from an equitable standpoint, it might cost hundreds of thousands of dollars to correct that error.
Yeah.
And so, in that scenario, if the parties agree, maybe it's just a variance to allow them to move forward with it, as opposed to having to rip it up and pour out a ton of money.
Interesting. All right, we can go back on track now.
All right. No, good question though.
Civil Code 4765, the architectural review procedures. The architectural decisions must not be arbitrary or capricious, as stated. Decisions must be made fairly.
Again, that goes back to just the general spirit of Davis-Stirling, and also what's often memorialized in the governing documents. It's the equal application.
Yeah.
In the spirit of association law, everyone needs to be treated equally. And so again, it's trying to avoid that scenario where, hey, we like these people, so let's give them the free pass, but we don't like these people, and let's deny their applications. That's what this is.
Yeah. Civil Code 5975, enforcement of governing documents, provides homeowners a legal mechanism, allows enforcement of CC&Rs against a board that fails to uphold them uniformly.
Again, this is a scenario where you're getting fined, you're getting enforcement action, and nobody else is.
Yeah.
That in and of itself becomes a massive problem. It becomes a violation of the Davis-Stirling, and it likely violates the CC&Rs themselves.
Yeah, which is what you're saying. Yeah. This is almost the provision that you can enforce. The law says that you can enforce the governing documents, right, which if there's a provision in said documents, there could be 2 causes of actions like you were saying. Yeah, interesting.
A little more firepower.
Yeah. Okay, let's talk about, again, back to California, the AB 130 shield. California recently passed AB 130, which we have a whole episode about. Shameless plug here. We actually were in Sacramento for that as well, which was really cool.
LA Times picked up that whole situation. That was very cool.
Yeah, it was. So that I think it was back in July. So again, shameless plug. You can go back to July of 2025 episodes there that discusses this in much greater detail. Okay, California recently passed AB 130, which caps fines at $100 and eliminates interest, and the late fee. This prevents a bad board from weaponizing selective enforcement into a massive debt or foreclosure leverage, which that one, foreclosure leverage, let's just, that was a scary one because we saw that several times where they would just squeeze and the looming foreclosure was quite scary.
Well, Sacramento was very intelligent with AB 130.
Yeah.
And they saw, or they listened, you and I have been talking about this for a long time, the weaponization of fines and how dangerous that can be. Not only dangerous from an economic perspective, but from a potential loss of property. Because once an association gets bullish on fines, or what they did historically before AB 130, all of a sudden you get $5,000, $10,000, $20,000, $100,000 in fines.
Yeah.
And you can't pay it.
Yeah. And
now they're moving into some sort of foreclosure action. And you might lose your house, all because you had a bad board and you had the wrong paint color, or your lawn was, not up to subjective standards.
Yeah.
And so AB 130 really undercut the weaponization of that fine mechanism.
Yeah. Which is tremendous.
Yeah. But yeah, look at our AB 130 if you want a deep dive into that, because that was very exciting.
So much of our podcast has been, we've really leaned into the idea of what can a homeowner do on their own without needing an attorney. What are the steps that they can take to solve issues like this? Right. So again, we've done a whole thing on the strike method, right, in the past, and we can kind of break it down. But in this situation, we'll kind of fine tune it for selective enforcement. So the strike method is a methodology that we had come up with that specifically outlines the steps on what you can do to try to solve a dispute without an attorney. Yeah.
So looking at strike in the context of selective enforcement, you kind of go back and say, okay, you're a homeowner, you're dealing with selective enforcement. You have a bad board, you have a tyrant, and they're attacking you. So how do you approach that?
Yeah.
And strike is really the concept of how to think about it, how to frame it, and then how to proceed within an actual structure.
Yeah.
As opposed to the natural reaction, which is, raising hell, which I get, and it makes sense because you're so frustrated, you're under attack. The board member's a tyrant, and so natural inclination, natural human instinct is to just write horrible letters to the board and everybody and just light them up.
Yeah.
But we wanted to shift and elevate the approach, make it much more strategic, make it much more tactical in nature, hence strike.
Yeah.
So let's go through it.
Okay. Strike, for the people that have not heard it before, is actually an acronym, right? Like a government agency over here. Okay, the first S is stay calm. Remove emotion from the situation. A 3 a.m. angry email gives the HOA ammunition. I think that's a very, very important point. Assume a judge or mediator will read everything you write, even if it's super early, and be clinical. Keep the emotions out of it.
Yeah. So this is a big one where, those angry emails, they feel good, but they're going to be used against you.
Yeah.
Assume that. So maybe write the angry email, don't send it, sit on it, and then go back into it. Or even with the advent of AI, write it, put it into AI and say, hey, take all the emotion out of it.
Yeah.
If you don't want to proofread or edit your own stuff. But again, the more clinical, the more reasonable, the better. That's how you start to gain leverage on these.
Yeah. If you need to get it out on paper and get that emotion out on paper and then put it through AI to say, okay.
Or just journal about it on the side. And actually all right. So stay calm is S.
Yeah. That's a big one.
And that's not only for the written word, but also in your reaction or your interactions with the board.
And we have to, so we said, assume a judge or mediator will read everything you write. But also the flip side of that coin is we're going to assume that everything that the HOA side puts out will also see a judge or mediator. Right. So we've said this multiple times, and I love this idea that you've said before is on that side, you want to be the one that's always remained calm.
You want the clean record.
Yeah, you want the clean record. So you can say, we've been super reasonable this entire time, whereas look at all these communications. I've been bullied. I've been harassed. I've been from the other side. So I think I love that idea.
One thing with track everything, and this is a little bit of a nuance, I would argue it's more of a pro tip, But if something is said on the record that's incorrect, the onus is on you to correct it.
Oh, interesting.
So and this is very common with the board, they will misstate, they will falsify history. I mean, they're very common. And if you receive an email which is filled with falsity, respond to it set the record straight, reject it, and clarify. Because if you don't, there is an argument that if you didn't respond to it, that becomes the record. So you have to, be monitoring this chess game that's unfolding. And if they take advances and they say, hey, you said this, this, and this, which is fundamentally untrue, respond in writing, telling them that that's not true. This is what actually happened.
Yeah.
But again, be clinical in that approach. But it's very important to respond to allegations, especially when they're false.
Yeah. Oh, interesting. Okay.
That becomes part of track everything.
So yeah, track everything. If it's not in writing, it didn't happen.
Right.
I love that line. If the board president verbally approves your project, you need to memorialize it. So you can write back, this confirms our conversation. If this is inaccurate, please respond in writing. I love that idea as well. Just memorialize everything and make sure everything's neat and tidy.
Well, that last little part of this is inaccurate, please respond in writing. That's really powerful. So
because they might not too.
Correct. So I would definitely encourage people to add that.
Interesting. All right. The R, record and organize evidence. Build a clear timeline of evidence. Take time-stamped photos and document preferential treatment.
Yeah, here is just this general concept and encouragement to sort of have a wherewithal of the situation. If something happens, document, photograph, because it's very easy for a bunch of time to pass and you're like, oh, I forgot to take a photo of that.
Yeah.
And if no one has a record, it's harder to prove up. Now, of course, you can testify, you can sort of be a witness to the situation.
Yeah.
Always best to actually have concrete evidence, like photographs, video, etc.
This also, let's assume that you fast forward to where you get an attorney. One of the, even I think this week this happened with one of the consulting attorneys that said, hey, this person showed up that watched the podcast and showed up extremely organized. Right. Which there is an economic value to that as well. Should you get in front of an attorney and you are clean, organized, and precise, it's easy for an attorney sitting on the other side to be able to parse through what actually happened. And then there's not a lot of back and forth and having to go through evidence.
Right. Look at it from a UX perspective, user experience.
Yeah.
Now, attorneys are trained to go through a lot of information, a lot of disorganized information. I can't tell you how many times I've gone through hundreds of banker boxes, putting together a file, trying to understand, okay, what's the whole story? But the more you can do that, and you're in a great position to do it because you lived it, the better it is for the attorney to access that file, but it also saves you money.
Yeah.
If you can lay it out, if using that empowerment kit.
Yeah.
I mean, that was really engineered for two purposes. One, to get the information in front of a board in a very clear, concise way. Yeah. But also, if attorney intervention is required, it's teeing it up for that advocate to go through.
Yeah. I mean, you just mentioned it on the record and organize evidence, the homeowner empowerment kit. We shamelessly showed it earlier, but there is a digital version
Where can they get that?
The subreddit Bad HOA. It is there, so you can download it for free. It's just a good way of it's already pre-organized. It's already kind of templated out for you. All you need to do is fill in the gaps, take out what you don't need, and it should be all organized and ready to tee up.
Very good.
Okay. I invest in knowledge. Read your CC&R. Understand the hierarchy of law, which we've said multiple times on this podcast. And you can go through that if you like, just kind of talking about the hierarchy.
Yeah. Always look at it from the perspective of, federal is always at the top of that pyramid. Yeah. Then you have state, local, and then your CC&Rs come into play. Yeah. And to the extent that there's a conflict, let's say your CC&Rs conflict with state law, state's going to prevail. Yeah. Or if it conflicts with federal law, then federal is. So there is that tension between these different types of laws, whether it's state or federal. Just be mindful of that.
I think what most people say, well, how often does that happen? And I think what they don't realize is that laws change. I mean, California, we had the ADU changes, 2 laws that were even this last year that kind of came to fruition about the ADUs and also solar and drought tolerant landscape.
Or AB 130.
Yeah.
Right?
Yeah.
I promise you, there's a lot of antiquated fine schedules that still exist in these CC&Rs
100%.
or these, right?
100%. So now that California said no more, nothing can be fined over $100, but your CC&R says, well, no, this is on the 3rd offense, it's $750 for this thing. That is out the window. The CC&Rs don't count because California law trumps the CC&Rs. But I think that's a good point of just going back to reading your CC&Rs. I think so many people, I mean, I've done this when my last home was in an HOA. I didn't read my CC&Rs. Luckily, I didn't have a dispute, but to the extent that you do, I mean, reading it and understanding where your rights are is incredibly important.
Well, I also think, listen, I recognize that it seems daunting and overwhelming, and where do you start?
Yeah.
And, when you approach a CC&R set or governing documents that are 300-400 pages, maybe you don't need to read it from cover to cover. Now, if you do, that's great. I think that's really an empowered homeowner, and that's fantastic.
Yeah, bookworms.
A student. But if you want more of a casual way to approach it, just to kind of get bearings, start with the index.
Yeah.
Just open it up, kind of see what it covers.
Yeah.
And, if you really focus on the common areas, if you look at what their obligations are, and just get a general sense of the sort of bigger infrastructure, that's a good starting point too.
Yeah. I mean, and even so, like, if there are OCRs where you can look for things,
OCR is great.
Yeah. And then the unequal application. I mean, you can start doing some keyword searches and then find it in your CC&Rs. I mean, it's all, you're already protected in the
with the Davis-Stirling
Act, but you could also have a second cause of action should they be in your CC&Rs as well.
Correct. So yeah, if you can OCR it, that's great. Index is really helpful. But these are just ways to sort of pierce those documents, make it a little bit more accessible.
Yeah. We have K, keep it precise. Elevate your vocabulary. Don't say you're violating the rules. Say you're violating CC&R provision 3.71 on page 9.
Well, I think there's levels to keep it precise, right?
Yeah.
And I think the natural way to approach it is the board is often awful and you're a dumpster fire. That's a very blunt way of saying it. A more precise way of saying it is you're violating the CC&Rs. An even better way is, you're violating CC&R provision 3.71.
Yeah.
Right. So there's different levels of it. And the more precise, the more powerful it is.
Yeah.
And it will get better traction.
We've always said elevating your vocabulary shows that you mean business, that you know what you're talking about. You probably shouldn't be messed with. You're an empowered homeowner.
Well, look at it this way. I mean, if you elevate that vocabulary and wear the sweater, force to be reckoned with.
Force to be reckoned with.
Yeah.
Okay. The last is E, escalate only if necessary. Request informal dispute resolution, otherwise known as IDR, under the Davis-Stirling Act. It forces the board's hand to meet with you before attorneys get involved.
Yeah, listen, IDR is always a very powerful tool if it makes sense and the board is receptive.
Yeah.
Yes, under the Davis-Stirling, you can demand IDR. The board, in theory, could say, go kick rocks.
Yeah.
Now, that shows tremendous bad faith, and I think ultimately that is going to be a very powerful piece of evidence that you tried to offer an olive branch and it was shot down. But it's not a bad opening move, even if you know it's not going to actually move the needle.
Yeah, because again, assume that this is going to get in front of a mediator or a judge.
Right.
And if they don't respond, or they say, hey, this homeowner, they tried to work this out. They've been very reasonable.
Well, it's a reasonable play.
Yeah.
IDR is a very reasonable play, and it shows that you're actually trying to resolve it without sort of court intervention or lawyer intervention.
Yeah.
So.
Okay. So that would be the steps to take to try to resolve it on your own. Let's jump in to the red flags when you think you should lawyer up. You ran the strike play. It hasn't, maybe it didn't work. The board is acting terribly. Let's look. There's a few red flags that we've outlined it here. So hostility or aggression. We've mentioned this before. If you're dealing with a tyrant and you know they're out of control,
you may not want to subject yourself to a tyrant at an IDR.
Yeah.
They're so belligerent, they're so over the top. It's just going to be a yell fest. It's not going to be productive.
Yeah.
Maybe sidestep it.
Yeah.
That could be. You see the writing on the wall beforehand. You don't need to run into the burning house.
Yeah.
You see.
Ghosting or gaslighting. They ignore your IDR requests. They ask you to submit identical documents multiple times. That has to be incredibly frustrating.
Yeah. So the ghosting is a major problem, especially with association, and they just ignore you. You have a real pressing issue. Let's say it's, real targeting. You're under the gun on several different fronts. You're trying to get it resolved and they just ignore you. They stonewall you.
Yeah.
That's a problem. Or they flip the script and make you sound like you're out of your mind. Okay, well, yeah, maybe IDR isn't going to work because now you know the people that you're dealing with.
Yeah.
So at that point, you may want to ratchet up and at least start speaking with a lawyer or an advocate.
Yeah. They weaponize a lawyer. You receive a threat letter from the association attorney. You need representation to avoid legal traps or being outmaneuvered.
So when they show up with a lawyer or an advocate or you get a lawyer letter, in my opinion, it's always best practices to at minimum speak with another lawyer. Your lawyer, not their lawyer.
Yeah.
Talk to a lawyer. Get an idea of what that lawyer's doing. Because if they're going the legal route, they could be doing certain things that could impact your rights.
Mm.
So best to get someone who understands this area of the law in as quickly as possible to sort of read what's happening. Now, it could be a bluff, or they could be laying a foundation for some sort of lawsuit or some sort of adverse action against you.
It's just hard to know whether the attorney might come off super reasonable and wants to hear your side of the story and thinks, hey, I'm on your side or whatever the case may be. But at the end of the day, they are on the side of the HOA.
They represent the association as entity,
right.
And it's always best to have your own independent counsel.
Yeah.
It just is.
Yeah. By minimum of a consult.
Minimum, yeah.
Okay. Number 4, property or financial threats. Threats of lien or foreclosure or refusing to fix common area issues causing serious property damage like a roof leak.
Yeah, and this becomes a realized threat. Either they're moving forward with some sort of foreclosure action or there is ongoing damage to your property. Maybe, there's some sort of, let's say, preferential treatment where they're, maintaining everyone else's slope, but they're not yours.
Yeah.
And your house is going into the ravine, or there's water intrusion where everyone else they're assisting.
Yeah.
The board president just doesn't like you and they're leaving your damage as is.
Mm.
So these are scenarios where, it might be time to shift up.
Yeah. As we wrap this thing up, we've always said that the homeowner carries a tremendous amount of power. They just usually don't know that they do, or they don't know how to wield it. And I hope that if anything comes from this podcast, it's that they do.
Yeah. Well, yeah, it's twofold, right? It's that, there is power. They're not powerless in the situation. They need to know where to look. And they also need to know how to execute on it as well.
100%. So much I've seen on Reddit is people just saying over and over and over again that the HOA has so much power. And I think that, and we've said it too, no, the homeowner has tremendous power. I think it's worth the clarification that the HOA does have power, right? They clearly have it under the law. The CC&Rs are legally binding, just like any other business contract. And by going into this neighborhood, you have signed on the dotted line, if you will, to those things. That doesn't give them carte blanche to do whatever they want, though.
Correct. And I think that's the big difference, right? They have power, and that power exists as it's articulated in the, governing documents and in the Davis-Stirling Act.
Right.
Those are the confines of their power.
Yeah.
And when they start stepping outside of that, there's a lot of regulation. There's a lot of sort of enforcement action that you can do once they cross that line.
Yeah.
And that's the difference. And that's the nuance of this, of what we're saying.
I mean, the Davis-Stirling Act is fairly substantial, where they want harmonious associations. They want harmonious communities. They put certain things in there to try to work this out without legal intervention too.
Right.
So I think that I just wanted to clarify because I keep saying, I mean, I've seen the memes on there too of people like, oh, you say that the HOA doesn't have all the power. They don't have all the power. They do have power.
Of course,
but the homeowner,
of course they do.
Yeah.
But it's when they start abusing that power.
Yeah.
That's when you come in.
Yeah.
So very good, Marty.
Yeah.
All right. Well, another successful episode. Thank you guys for watching. We appreciate it. Again, like, subscribe, leave comments, and then go to the subreddit. If you want the merch, sign up for it. Again, limited drop, but we're happy to send it your way. And thank you guys for watching.